It is clear to me that the law ties itself in knots over medically hastened deaths because it applies the same law and legal principles to such medical deaths as it does to vicious murders. It then tries to justify the obvious problem this causes by dodgy precedents, dodgy arguments about causation, and by turning a blind eye to much that goes on. To paraphrase Shakespeare, the law is honoured more in the breach than the observance. It assumes that medical practice is above board. It probably is, but how would anyone know? Don't forget Dr. Harold Shipman. There are two long-standing legal principles which to me are integral to the problem. The first is that consent is not a defence to crime. Consent as a reflection of autonomy is a fundamental principle in medicine, and it changes many medical acts from criminal to acceptable. It is the most powerful way to determine that suffering is intolerable and that life-threatening palliation is appropriate. It converts medical acts that might be dubious to acts that are transparent and correct. I suggest that consent is of the greatest importance in establishing a new paradigm for medical acts that hasten death. Medical acts that hasten death are unique. They are the only acts in the drama of human-affected death where the view of the central player, the dying person, can be reliably established. Why is this not taken into account in law? It is a gold standard that should always be demonstrated when making an ethical and, I would say, legal judgment. After all, consent makes sexual intercourse a legal act of love. Without consent, it is a crime. Physician-assisted dying, in my opinion, may also be occasionally an act of love, but it is always an act of respect. The second issue is intention, which is the cornerstone of criminal prosecution in capital matters. Where a known criminal shoots at close range and kills for payment someone he has never met, it can be reasonably argued that it was his intention to kill. Intention is not always so clear. Medical intentions are complex. Dr. Timothy Quill wrote, "Multi-layered intentions are present in most, if not all, end-of-life decisions." Jessica Corner, Director of the Centre for Palliative Care Studies at the Royal Marsden Hospital, confirms this complexity. The easing of death as an intentional double effect is commonplace in palliative care and general practice. That is to say, both intentions, palliation and easing, or one might say hastening of death, are present. She went on to say, palliative care needs to take the lead by making clear the strategies it employs for managing difficult situations at the end of life, and when double effect is used, with a view that death is a likely and welcome secondary consequence. To be open about this, note that death is a welcome secondary consequence. I completely concur with this position and believe that in every instance where a doctor hastens death, he or she does so with the primary intention of relieving suffering, but acknowledging that death may be an unavoidable consequence. This is so whether the intervention is by deep continuous sedation, lethal injection, or the provision of medication for the patient's ingestion. To attempt to distinguish some palliative acts as having the primary intention to kill while maintaining that others do not have that intention or only a secondary intention is foolish. The Council of Judicial and Ethical Affairs of the American Medical Association wrote, "The ethical distinction between providing palliative care that may have fatal side effects and providing euthanasia is subtle, because in both cases the action that caused death is performed with the purpose of relieving suffering. A final comment on intention from Professor Lowy. At least in law, and I would reasonably hold the same true for ethics, one is responsible not only for what one has clearly intended, but also for what one could reasonably foresee. In terminal sedation, not only is the patient's death clearly foreseen, it is in fact the end point of what is being done. Clearly, and however it may be cloaked by the loose use of language, the intent here is more than just the clear goal of relieving pain and suffering. Because the goal of relieving pain and suffering adequately can be attained only by obtunding the patient until death ensues, the patient's death becomes the end point, and therefore one of the intended goals. These goals do not differ from those of physician-assisted suicide or, for that matter, voluntary euthanasia. Terminal sedation, we would claim, differs from some form of voluntary active euthanasia, mainly in that it has not been and is unlikely to be challenged. While Lowy points out that an intention of deep sedation is to hasten death, he argues that it is not the primary intention, which is to relieve suffering. The occurrence of death is very much a secondary intention, an unavoidable intention. His analysis confirms in spades my third medical given, that some suffering will only be relieved by death. In 1992, Dr. Nigel Cox, a respected British rheumatologist, could not relieve with morphine the appalling pain of his patient with end-stage rheumatoid arthritis. She and her family pleaded for his help to end her suffering. Like me in 1992, Cox had not heard of terminal sedation. Cox injected her with potassium chloride and recorded the fact. This was a drug with no effect other than to stop the heart. He was convicted of attempted murder. Had he injected her with the potentially lethal sedative pentobarbital, he would almost certainly not have been charged. To hasten her death with a barbiturate would be palliation, but with potassium it was murder. Dr. Cox, a decent, honourable professional, acting in the best interest of his patient, was sacrificed upon the legal altar to maintain the facade and humbug of established judicial practice. To prove my point, he was given a suspended sentence for attempted murder. One has to ask whether the drug used to hasten death or the time taken to die, either quickly or slowly, are sufficient reasons to distinguish between a criminal act and good medical practice. It is a fact that a doctor can prescribe and deliver injectable drugs, clearly foreseeing that they will hasten or cause death, providing they are the right drugs, those with approved therapeutic effect. In the same circumstances, a doctor could also prescribe drugs for oral consumption. In my book, I relate how I prescribed oral morphine and sedatives to my patient with terminal prostate cancer, the same drugs as used in terminal sedation. I could foresee that he might use them to end his life, and he did. I reported it to the police and was not charged. In fact, I believe I could not be charged, even although it could be argued that I had aided and abetted his suicide. I describe how I prescribed oral barbiturates to Susan, a young woman with an inoperable brain tumour, explaining how the drugs might be used to end her life. However, in the end, Susan died by terminal sedation, naturally, as it were, 2.5 years later. She did not use my medication, but it provided enormous palliation by giving her the sense of control over the end of her life. She had what the Melbourne Age journalist Pamela Bone described as the knowledge. No amount of gratuitous reassurance could have given her that security. In 2005, I assisted Steve Guest to die. He had terminal esophageal cancer and despite tube feeding was wasting away in pain. Steve died of a lethal oral dose of pentobarbital. I stated to the press and the police that I had given him control over the end of his life. and additionally on radio and television that I'd given him advice about barbiturates and that I'd given him medication. The coroner, after detailed discussions with the police and the DPP, has closed the case without an open inquest, despite it being requested by Steve Brothers and myself. Was this the oral equivalent of double effect by injection? One has to ask, is aiding and abetting suicide a crime in the medical context? Is medical practice again creating a new interpretation of the law? Maybe, but good law depends on the defined and refined use of language. There is no good law where the language does not exist. Steve's death provided the final impetus to my view that there is a benign conspiracy between the police, coroners, prosecutorial authorities and government to avoid prosecuting doctors who help their patients to die with their consent and for the relief of their suffering, even if there is strong circumstantial evidence that the law has been broken. In my opinion, this conspiracy occurs because the authorities see that doctors are between a rock and a hard place, and the authorities themselves are between a rock and a hard place. Yet these same authorities prosecute so-called lay mercy killings, piously invoking the need for deterrence and the rule of law, and yet ignore these principles when the medical profession is concerned. They rely on our judges to inflict no penalty on these unfortunate people. Which leads me to ask, what is the law relating to hastening death in a medical context? There is a chink of enlightenment in the preamble to the Victorian Medical Treatment Act of 1988, which says the Parliament recognises that it is desirable to ensure that dying patients receive maximum relief from pain and suffering. Does this justify my providing Steve Guest with advice and medication? Not, I am afraid, without a judicial precedent or statutory law. There is no law that any doctor can rely on. This situation means that people with similar medical contexts will receive widely differing outcomes. It is entirely arbitrary as to whether they get the treatment they want. It depends on their doctor's training, experience, beliefs and courage. It depends on the nature of their disease and where they are being cared for, in a public environment such as a hospital or the privacy of their own home. And it depends on the sufferer's education, influence and awareness of the medical system. As philosopher Professor Ronald Dworkin stated in the Philosopher's Brief to the US Supreme Court, the current two-tier system, a chosen death and an end to pain outside the law for those with connections, and stony refusals for most other people, is one of the greatest scandals of contemporary medical practice. The outcome does not depend on the law. These are not the hallmarks of a just legal system. Yet many doctors, including those in palliative care and the Australian Medical Association, support this status quo, which can only be described as covert, cosy, malleable and hypocritical. Medical practice at the end of life is a unique area of human endeavour that requires particular regulation, but none exists. I've argued that the law has failed to develop in response to changes in modern medicine, in end-of-life complexities, and also to changing community attitudes. The law seems to allow, without any scrutiny or guidelines, death-hastening acts, some of which are considered to be legal and some not. The law seems to allow certain palliative acts that are not those that most people would prefer, and denies others that they would choose given the option. It has relied on vague precedents that accept that if medical acts are intended to be palliative, they will not be prosecuted. Because of this black hole in the law, medical practice at the end of life is entirely arbitrary, depending to a great extent on the courage and moral view of your doctor. Surely the rock can be moved and the hard place softened. It can be done based on the principles of autonomy, as reflected by consent, and the necessity to relieve suffering as reflected by palliative acts. At the end of the day, it is not doctors who suffer because of the black hole, but their patients. One day, that might be your mother, or your father, or it may be you. Thank you.
Ladies and gentlemen, whatever you think about his views, I'm sure you would agree that Dr. Syme makes a thoughtful and forceful contribution to public debate about the decent treatment of terminally ill people. Part of that advocacy involves stirring the pot a bit, for which the media can also take some share of responsibility. But what is typical of Dr. Syme's advocacy, it seems to me, is that never once does he duck the issue of the doctor's role and responsibility for involvement in assisted dying. There are no technical shenanigans and do-it-yourself suicide machines. There are no euthanasia ships moored just outside Australia's territorial waters. But instead, in A Good Death, you have a very frank account of a physician grappling with the real challenges of relieving distress and anguish. In my short rejoinder, I'd like to focus on one key idea of Dr. Syme and to see where it leads, and that's the idea of intention. Medical law and ethics puts great store in doctors' intentions. When you're dealing with sick and frail people who may die soon anyway, the doctor's intention is one of the main ways that society distinguishes palliative care physicians who provide humane pain relief from its medical killers, like Harold Shipman. You'll be aware that the compassionate motives of a healthcare worker don't provide a lawful excuse for intentionally hastening the death of a person with a terminal illness, and nor does the consent or the request of that patient. And nor can a doctor plausibly deny having the intention to hasten death when death is the only possible or foreseeable consequence. There are two qualifications to these principles. The first is that patients have the right to refuse medical treatment, and that includes life-preserving medical treatment like intravenous hydration and ventilation. And the reason for this is that treatment without consent is an unlawful assault, and doctors aren't allowed to assault their patients. The second qualification relates to pain relief. I'm confident that Australian courts would find that it is lawful to administer generous amounts of analgesics and sedation for compassionate motives in order to relieve distress and suffering, even if this suppresses respiration and thereby hastens death. The problems would only arise, I think, when the dose is so disproportionate to the suffering of the patient and so outside the boundaries of medical practice that killing the patient could be imputed beyond reasonable doubt as the overriding purpose and the goal of the whole exercise. And in the meantime, I think it likely that courts would frame the intention of the physician as being to provide relief from suffering, even if achieving that purpose had the concurrent effect of hastening death, and even if the doctor knew that. So this leaves us with the difficult cases of where distress can only properly be relieved through unconsciousness until death intervenes. Now, in his book, Dr. Syme describes giving a large dose of morphine to a man who was dying from congestive heart failure. He was blue in the face and gasping for breath. My primary intention was immediate palliation, Dr. Syme writes, but to be honest, I had a secondary intention of bringing his suffering to a final end. That could occur only through his death. His suffering would simply continue until he died. So rather than watch him gasp his way to a slow death, Dr. Syme sent him to sleep, and I certainly don't fault him for that. But the legal status of palliative sedation as a spectrum of practices is one of the most interesting issues that Dr. Syme raises in his book. Now, those who oppose euthanasia might be bewildered to learn that Dr. Syme has reported his actions to the Victorian coroner on a number of occasions and has eventually been told that what he was doing was perfectly lawful. Now, Rodney, why I expect that some members of the audience out there might be willing to take you into custody, to get arrested you first need to do something unlawful. It's the way it usually works. But more seriously though, Dr. Syme's challenge is that the law leaves doctors to sweat about their legal risk. And by taking away legal uncertainty, it undermines their willingness to provide adequate palliation. Intentions are frail, Dr. Syme says. In cases where relief from suffering cannot come until death comes, palliative measures to relieve suffering start to look a lot like actions designed and intended to cause death. Rendering a patient unconscious, denying fluids and waiting until they die looks pretty much the same as giving a lethal injection that achieves death more quickly, except for the time lag, and that's the core of Dr. Syme's argument. He doesn't say that the failure of palliative care justifies physician-assisted suicide. Instead, he says that physician-assisted suicide and euthanasia are the missing pieces in the spectrum of palliative care. And he says this because in both cases the doctor's primary objective is to relieve suffering. But insofar as a doctor does have an intention to hasten death, it's a derivative intention. He or she is driven to it because of their primary commitment to relieve suffering. So in summary, I think that Dr. Syme would argue that palliative sedation and lethal prescription are both forms of palliative care, and they may both be morally indistinguishable forms of physician-assisted dying as well. And if courts and the coroner are happy for palliative sedation to be explained solely by reference to the doctor's undeniable intention to relieve distress, why shouldn't the lethal injection be explained in the same way? As someone who teaches public health law, I'm familiar with the idea of multiple causes. In public health, we talk about global factors, national factors, local environmental factors, individual behaviours, genetics and healthcare interventions as all interrelating to produce states of health for the individual and the population. So it seems to me that recognising the role that a patient's underlying illness plays, as well as the role that palliative interventions may sometimes play in influencing or hastening the time of death, is really a big step forward in terms of medical honesty. And similarly with mixed or multiple intentions. The problem, it seems to me, is that we want to believe that doctors don't play God. I would say that doctors play God more often than we realise. That's one reason why we want doctors to be virtuous. That's one reason why we as a community have the right to subject medical practice to a degree of oversight and regulation. They're not neutral bystanders. Now, we can legislate all this into oblivion, as South Australia has, and reframe intention and causation so long as a doctor acts in good faith and in accordance with professional practice. But that still leaves the moral issue. And I call this moral issue the devil's choice. The characteristic features of the devil's choice are that all options are perversely constrained or limited. And secondly, not choosing is not an option. The classic devil's choice was Sophie's Choice in the film of the same name. Meryl Streep, a Polish mother, arrives at Auschwitz and is given a terrible choice by a Nazi soldier. Choose which of her two children will be sent to the ovens and which will live. And if she doesn't choose, the soldier will take them both. There have been other dramatic examples of the devil's choice in medicine. For example, when conjoined twins are both likely to die without surgery and surgeons must decide whether to operate to save one, knowing that the other can only die. I don't have time to develop this argument, but it seems to me that a more honest way to frame palliative sedation is to see it as a kind of devil's choice. It's a choice between two perverse options. Either sedate the patient in a way that ends their suffering and take responsibility for hastening the time of their death, or give them inadequate analgesia so that they keep waking up in pain and you progressively titrate the dose as you fail to control their suffering on each occasion. And remember, fleeing the hospital ward to become a lawyer is not an option. So, as you can guess, I have some sympathy for Dr. Syme when he argues that we should have a defence of necessity to protect doctors in hard cases. As a public health lawyer, let me end by provoking you a little. It's not my intention to offend you, but after I've said that, who's going to believe me? The field of bioethics has an intense interest in medical issues that relate to the life and death of individuals, but rarely ever populations. Euthanasia is one issue that has what I call moral colour. Everyone agrees it's a moral issue. There are heroes and villains, and you can see some of them on the screen, and the media and the public are endlessly fascinated. At the same time, the specific basket of life and death issues that we ascribe moral colour to is quite arbitrary. Perhaps it's even perversely limited. By way of example, here is a picture of the Pope giving an audience to the Marlborough-sponsored Formula One motor racing team. Don't fool yourself, this is advertising beyond price. Marlboro is the world's biggest selling cigarette brand. The World Health Organization says that smoking killed 100 million people last century and that it's going to kill 1 billion people this century. Now, like euthanasia, smoking raises issues of personal choice. And did anyone mention slippery slopes and unintended consequences? It seems to me that we have become sensitised to the value of life within the field of bioethics, but we have a long way to go in the field of public health ethics and environmental ethics. Dr. Syme has set about rocking the boat with his oration this evening. He's given us a lot to think about, and for that I thank him.